The good news is 10 o'clock, 10 o'clock. Well, this is the
Silence, all stand and remain standing. The Federal Circuit and Family Court of Australia Division 1 is now in session. Please be seated.
Thank you. Please open the court.
On the occasion of the ceremonial sitting to commemorate the 50th anniversary of the Federal Circuit and Family Court of Australia Division 1, Adelaide, South Australia.
I would like to begin by acknowledging the traditional owners of the lands and waters where we meet today, the Kaurna people, and extend that respect to any Aboriginal or Torres Strait Islander person present. Our courts sit across this great country, and we acknowledge and thank the traditional owners of all the lands on which we sit. We recognise the unique and ongoing spiritual and cultural connection to this country maintained over thousands of years. On behalf of the court, I express our gratitude for the sharing of this country. I also express my sorrow for the cost of that sharing. I wish to understand and respect the stories, beliefs and laws of First Nations people. It is our hope we will move to a place of equity, justice and reconciliation together. I pay my respects to elders for the work they do as they continue to lay the bedrock for the next generation of Aboriginal leaders. We commit to walk with the greatest respect on Aboriginal lands. Good afternoon and welcome to everybody here to this ceremonial sitting to mark the 50 years of the Family Court of Australia. I acknowledge the presence of our distinguished guests, including judges sitting with me at the Federal Circuit and Family Court of Australia Division 1, formerly the Family Court of Australia, and judges of the Federal Circuit and Family Court of Australia Division 2, including those joining us remotely. Justices O'Sullivan and McDonald of the Federal Court of Australia. My good friend Justice Livesey, President of the Court of Appeal of the New South Wales, for the Supreme Court of South Australia. It's been a bit of a national celebration, as you can tell. Associate Justice Michaels of the Supreme Court of South Australia. I acknowledge former Justices of the Family Court of Australia and Chief Justices, particularly the Honourable Elizabeth Evatt AC, the Honourable Alistair Nicholson AO RFD KC, the Honourable Diana Bryant AO KC, and the Honourable John Pascoe AC CBO, many of whom are watching us online today. Also retired Judges of the Family Court of Australia, including Steve Strickland KC, Christine Mead and David Berman SC. I acknowledge the dedication and service of our CEO and Principal Registrar, David Pingle, PSM, who is today fighting for us in Canberra to get more funding, and Deputy CEO and Deputy Principal Registrar, Virginia Wilson. Ms Marcella Benmu, Senior Executive Lawyer, Australian Government Solicitor, on behalf of the Commonwealth Attorney General. Ms Tanya Lewis SC, Chair of the Family Law Committee of the South Australian Bar Association. Ms David Kolovic, President of the South Australian Bar Association, the Law Society of South Australia. Ms Alison James, on behalf of the Family Law Section of the Law Council of Australia, members of the Bar, members of the profession and distinguished guests. Also, I'm told Mr Richards, who was in fact here as a practitioner in 1975 when the Act commenced, was a former registrar of the court and currently is in day 10 of a trial before one of our judges. Ms Lewis SC.
May it please court. I too acknowledge the Kaurna people as the traditional custodians on the lands on which we meet today. I pay my deep respect to elders past and present. The Family Court commenced on the 5th of January 1976, marking a fundamental shift in the practice of family law in this country. Prior to the Family Law Act, divorce was governed by each state's own Matrimonial Causes Act. To succeed in obtaining a divorce, a party had to prove one of a number of fault-based grounds, which included desertion, adultery, habitual drunkenness, or cruelty, amongst others. The practice of family law in those days was lucrative work for private investigators engaged to peer through windows and obtain photographic evidence of the grounds relied upon. Those photographs would ultimately be tendered in Supreme Court proceedings. The parties' full names were published in the newspapers in a divorce list. Lengthy trials featuring salacious allegations to establish fault consumed the Supreme Court's time and resources. So notorious was the process that it inspired a 1960s daytime television series aptly titled Divorce Court, in which actors reenacted real divorce cases. All that changed on the 5th of January 1976 when the Family Court was established as a Federal Court of Australia. The Honourable Elizabeth Evatt AO was the first Chief Justice of the Court and the first female Chief Justice of any court in Australian history at that time. She was joined by her 4 brother judges. Few practitioners, perhaps Mr Richards only in this room, will remember the first judge appointed in Adelaide being the Honourable Justice Marshall. Many more practitioners will fondly recall the Honourable Justice Kemry Murray, appointed to the Adelaide Registry on the 6th of February 1976, who went on to sit for the next 30 years, being the longest-serving judge of the court. The Family Law Act represented a seismic shift in the administration of family law, and it's worth remembering that shift had an Adelaide influence. Algis Radzivicius, who would go on to become a respected judicial registrar in the Adelaide Registry, was one of those involved in drafting the legislation when previously employed at the Attorney General's Department. Under the new Act, the only condition required for a divorce was that marriage had irretrievably broken down, evidenced by a separation period of 12 months. As one newspaper reported at the time, the bill was not aimed at the destruction of marriage, nor the disintegration of the nuclear family. What it would do was end a bad marriage relatively quickly in order that another, good, bad or indifferent, could be entered into relatively soon. For the first time, the court made property orders that were just and equitable as between the parties. Homemaker and mother contributions were given proper and meaningful recognition in property proceedings. Parenting orders were to be made with the best interests of the children as the paramount consideration. Counsellors were employed within the court to assist families caught up in litigation. Publication of proceedings or the identities of those involved were prohibited. Each party would bear their own costs. Specialist family law judges were appointed for their expertise and understanding of families in crisis, and the court adopted less formal procedures and practices. Those founding principles remain central to the administration of family law by the court today. As a demonstration of how much has changed since then, and perhaps how little, the newspapers of the day reported that the Chief Justice's salary in that first year was $31,700. A solicitor fee for a divorce was $200, being not dissimilar to the amount that legal aid pays counsel in Adelaide today for a half-day interlocutory hearing. The demand for a different approach had clearly been building. On the first day the court opened at Grenfell Street, in a building referred to as the Black Stump, solicitors lined up at the registry. 80 applications were filed in Adelaide that day, more than double the number filed in Sydney. South Australians, it seems, had been waiting. Nationally, the number of divorce applications had previously sat at around 25,000 a year. In 1976, once the requisite 12-month separation period had been served, 66,098 applications were filed. In Adelaide, the court remained at the Black Stump for 30 years, an office tower with limited security, multiple floors, and congested space for litigants, which on duty days more resembled stock being herded together, with lost litigants being called over the loudspeakers in the same way as you hear late passengers being called at the airport. As there was no separate entry for judicial officers, judges and litigants would occasionally have to perform the elevator shuffle, which would go a bit like this. The lift's doors would open on the same floor as the courtrooms to reveal the judge who had just been presiding over their matter. The litigant would step into the lift. Without a word, the judge would step out. The barristers would intervene, insisting the very confused litigant had to leave the lift. The judge would return to the lift before the doors would finally close, allowing the judge to go about their day. On the 2nd of February 2006, this building formally opened, with state-of-the-art facilities including open-plan waiting areas, dedicated entries for judicial officers, secure rooms for those who need them, the ability to conduct remote hearings well before we knew how often we would use them, and security screening. Whilst much has changed, the essence of the court has remained the same. The court continues to respond to the acute needs of litigants during the most challenging time of their life. For many, it is their only contact with a lawyer or the legal system. The judges, registrars, legal associates, court officers, family consultants and case managers continue to devote themselves tirelessly to the service of families and litigants, striving for a just and timely outcome for each party, often against a relentless workload involving allegations of trauma and distress. Counsel continue to appear before this court in circumstances that are arduous, with resilience, demonstrating intellectual rigour together with empathy and understanding as we endeavour to ensure litigants pass through the litigation pathway with as few war wounds as possible. The court continues to be dynamic in response to the needs of the families it serves by creating the Lighthouse program, the Elizabeth Evatt list and the Major Incident list, ensuring families obtain the urgent attention from the court whilst endeavouring to protect them from the consequences of family violence and trauma. The court has introduced the Indigenous list and Indigenous liaison officers, recognising the particular need to support First Nation litigants through the court process. In Adelaide, the Indigenous list is heard in a specially designed courtroom where Her Honour Judge Kelly sits on the same level as the parties with a round bar table reflective of a yarning circle, better suited to culturally sensitive and respectful exchanges. The court has also streamlined procedures for obtaining information from police and child protection authorities so that critical safety information reaches the decision maker faster. And in a program that never fails to bring a smile to an otherwise difficult day, the court has implemented the National Court Dog Program, whereby all court users, but perhaps mostly counsel, obtain the benefit of Court Dog Bonnie's calming presence in Adelaide. As the court did in 1976, the court continues to mirror the society it serves. On opening in 1976, one female Chief Justice sat with 4 male colleagues. Today we have an all-female Division 1 bench in Adelaide, comprising the Honourable Justices Kari, Parker and Stewart, being a fitting measure of the distance travelled in 50 years. On behalf of the South Australian Bar Association, I congratulate this Honourable Court on all it has achieved, a legacy as enduring as it is adaptable, and one on which the next 50 years will surely be built. May it please the Court.
Thank you, Ms Lewis. Mr Kolovic.
May it please the Court. I begin by also acknowledging the original custodians of this land and their connection to country. I also acknowledge the many current and former judicial officers present today. It's a great honour to speak at this ceremonial sitting on behalf of the Law Council of Australia and the Law Society of South Australia. In many ways, the evolution of family law and the Federal Circuit and Family Court of Australia has reflected the trajectory of Australian society. 50 years ago, divorce carried a very different social meaning. For many, it remained a source of stigma, even as a growing and vocal movement called for the end of fault-based divorce. A strong and effective campaign for equal treatment helped provide the momentum for change. As we've heard, prior to the Family Law Act, it was harder for a divorce to be granted. The fault-based divorce system had serious consequences. It left many families unhappy and unsafe. The precursor to the Family Law Act, the Matrimonial Causes Act, required in parenting cases that the best interests of the child be the fundamental consideration. But findings of fault in divorce proceedings had a significant impact on the determination of parenting arrangements, property settlements, and cost awards. The arrival of the Family Law Act was monumental and groundbreaking, and the introduction of a specialist bespoke court for family law was visionary. The new family law system was, though not universally supported, a truer reflection of the values of society at the time. There was debate about the impact of the new law on the family unit and whether it would destroy the fabric of society. In fact, what it did was empower spouses to make decisions about their own lives and make it easier to move on from miserable or harmful situations. Critically, the welfare of children was paramount in all matters. Recent amendments in 2024 and 2025 represent some of the most fundamental reforms in the Act's history. These changes clarified reforms about parental arrangements introduced in 2006. Those 2006 reforms introduced an assumption of equal shared parental responsibility, which Federal Parliament later conceded had been widely misconstrued by the community as creating an entitlement for parents to spend equal time with their child after separation. The 2024 reforms broaden the discretion of the court to tailor parenting orders to protect the best interests of the child. The reforms also expand the role of independent children's lawyers in parenting matters, and through them gave a further avenue by which the court could hear any views expressed by children. Tranche 2 of the amendments came into effect last year, dealing primarily with property and financial settlements. One of the major amendments was the recognition of the effect of family violence on parties to marriages and de facto relationships, and ensuring that where family violence has had or will continue to have a deleterious effect on a party, the court is able to take this into account when determining just and equitable property settlements. The Federal Circuit and Family Court of Australia and its predecessors, the Family Court of Australia, the Federal Circuit Court of Australia and the Federal Magistrates Court, of course, have been the main arenas in which the Family Law Act has been applied, interpreted and tested. But the court has not merely responded to changing societal values and attitudes. It has consistently been at the forefront of innovation, creating new solutions, processes and technologies, several of which have been at the cutting edge for their time. In 2020, the then Family Court and the Federal Circuit Court were at the forefront of adapting to the sudden need for virtual hearings. From courts which had previously conducted hearings in person, they virtually adapted overnight, ensuring continuing access to justice for litigants with barely a pause in their operation. Even in its infancy, the court employed counsellors to work with parties and present expert evidence. This was world-leading for its time, and even 50 years later, it's one of the only courts in the world that has parenting experts as employees of the court. It's not just the court where innovation in family law has occurred. Earlier this year, the Commonwealth Attorney-General announced that more than 17,000 separation matters have now been supported by Amica, a low-cost online tool which launched in 2020. As the attorney then said, Amica is an excellent example of how technology can make the family law system more accessible and affordable. Amica was funded by the federal government and developed by the Legal Services Commission of South Australia. The South Australian Commission still operates this national service. I acknowledge the efforts of Gabrielle Canny, who, when Director of the Legal Services Commission, led the development of this service. Many of us are only starting to come to grips with artificial intelligence. The development of Amica was, in hindsight, visionary for its time and a perfect example of how technology can be harnessed to enhance access to justice. This court must be commended for its constant efforts to support vulnerable people and streamline the resolution of family law. Significant resources have been invested into the early identification of risk, urgent response and proper allocation of resources to support those at risk of involvement in family violence, mental health issues, drug and alcohol issues, and child abuse and neglect. Some recent initiatives in the court include comprehensive risk screening, information sharing between courts and child protection agencies and police, and the appointment of court staff who are trained to support at-risk or vulnerable people. As we've heard, the court also has hired Indigenous family liaison officers, including 2 in Adelaide, and operates specialist Indigenous lists in 11 locations around the country, including Adelaide. We commend you, Chief Justice, on your unwavering efforts to innovate and support parties through their toughest times. Your Honour recently convened a family violence symposium describing the family violence epidemic as a national disgrace. That the court brought together such a wide cross-section of stakeholders shows its willingness to engage and to learn from experts and those with lived experience to arrive at strategies which best reflect contemporary practice. The evolution of the Family Law Act is a reflection of the evolution of Australian society and values. It's often said that the law lags behind contemporary attitudes, but the Family Law Act has, broadly speaking, reflected and led the Australian community's changing expectations and social mores. It would be remiss of me not to acknowledge the horrendous tragedy of the attacks on the family court between 1980 and 1985, which resulted in the deaths of Justice Opus and Justice Watson's wife Pearl, as well as injuries to others and the bombing of the Parramatta Registry. It was a traumatic time. The administration of justice should never entail exposure to violence or risk. The Law Council of Australia, the Law Society of South Australia, and the practitioners of this state recognise and commend the work of the court in supporting everyday Australians during what is a difficult time for most. The family law system is not perfect, but strives to provide safeguards against escalating violence, child abuse and financial manipulation, providing a path to safety, freedom and justice. For over half a century, this court has served the community well, and for that we are thankful. May it please the court.
Thank you. Ms James.
May it please the court. I echo the Chief Justice and my learned friends in acknowledging that we meet today on the traditional lands of the Kaurna people. I pay my respects to their elders past and present and to the elders of other communities who are with us today. It is a privilege to address the court on behalf of the Family Law section of the Law Council of Australia and its approximately 3,800 members across this country, and to do so here on behalf of the South Australian solicitors and barristers who practice in this building and who appear for South Australian families across this state, including all the Aboriginal people of South Australia. When the Family Law Bill was introduced to Parliament in 1974, the then Prime Minister, the Honourable Gough Whitlam, observed that the question of how best to enable broken marriages to be dissolved was very much a human as distinct from a technical legal problem. Before the Act, as my friends have outlaid, a person seeking a divorce was compelled to air their most private grievances in public and to prove the fault of another. The Family Law Act 1975, as my friends have mentioned, replaced that which, in the words of the Attorney General at the time, intended to avoid exacerbating relations between parties and with the interests of children as the paramount consideration. 50 years on, the how, the where, and the who of this court's work has changed a great deal, but the guiding light has not. This court, as my friends mentioned, came into being on the 5th of January 1976. 4 judges were sworn in before Justice Murphy in Sydney that morning. A 5th, Justice John Marshall, was on the same day here in Adelaide. From this court's very first day, there was an Adelaide bench. The court in South Australia opened in Grenfell Street, and it opened, as my friend indicated, to a flood of people. On that first day alone, it was reported in the newspaper that 195 Australians from South Australia came in or telephoned the Adelaide registry as to how the new law worked, and 80 filed applications in the Adelaide registry on that first day. Extra counter staff had to be found to simply answer the calls. There were queues and mountains of paper. As my learned friend mentioned, it was the start of this court. Justice Marshall was joined that same year in 1976 by Justice Kemry Murray, Justice Tom McGovern, and Justice John Gunn. Justice Murray was an Adelaide woman, the first married woman lawyer to be offered a partnership in a South Australian law firm, the only second woman appointed to judicial office in this country. She taught me court etiquette, to wear a jacket at all times before her in court, or she could not hear me. I have never forgotten since. She sat in this registry for 30 years, and when she retired in December 2006, she was the longest serving judge in Australia. The court moved from the Black Stump, as my friend referred to, as it became known in Grenfell Street, and moved to this purpose-built building of the Commonwealth Court building, which was opened officially in 2006. And it carries the name of Roma Mitchell, another Adelaide woman, Adelaide's first female judge, its first female Queen's Counsel, and the first woman to serve as governor of an Australian state. There is a fitting symmetry in that. A court whose first leader was Elizabeth Evatt and whose early Adelaide bench included Kemry Murray now sits in a building named for Roma Mitchell. None of them was content to be last, and none of them was. Those of us who have practiced for any length of time in family law have watched the rules and the processes of this court change and change and change again. The forms, the filing requirements, the language of custody and access to residence and contact, and then to parenting orders. Over the 50 years, we've had case management pathways, less adversarial trials. We now have electronic filing on the court's portal and online appearances. This is in addition to the successive rewriting of the Act itself. Some things have been abolished, only to be reintroduced in another form a decade later. This includes the role of judicial registrars. some today will still fondly remember Judicial Registrar Forbes, who sat in the Adelaide Registry. The practitioners have known to greet each other from time to time with each new iteration with a certain weariness or eye roll from time to time. But standing back across the 50 years, two things have never changed: the focus on the welfare of the children and the early resolution of disputes as safely and sensibly as they can be resolved. The high resolution percentage rate of family law matters and the constancy of purpose through all the changes is really what we are marking here today. South Australia is a small family law profession. We appear against one another constantly as solicitors and barristers in this court. That closeness, in my experience, is one of the greatest strengths of family law in South Australia in this court. A practitioner's word to the bench and with each other carries weight here. The duty of candour owed to this court is not an abstraction, but a daily habit upon which we all rely. And matters resolve outside the courtroom door and in mediation conference rooms because of the court, rather than it being litigated for years. They resolve because behind every negotiation, mediation, and FDR conference stands an institution with the respect and authority and the expertise to determine what cannot be agreed. And that's what we are here to celebrate today. Over the 50 years, the work of the court has not become simpler. As household financial arrangements have grown more sophisticated to protect wealth, this court has been asked to resolve questions including corporate structures, trusts, self-managed superannuation, and the tax consequences of proposed orders, while also carrying the hardest work in the family law system, matters involving family violence and risk, allegations of child abuse in the Magellan List, and international child abduction. The judges who sit in this court must bring both the sensitivity that family disputes demand and a command of commercial principle rivaling any other civil jurisdiction, often on the same day and in the same matter. Practitioners also see what does not appear in the judgments. We see judicial officers and registrars absorb day after day accounts of family violence, of harm to children, of heartbreak and trauma that would understandably overwhelm anyone, and then to move to the next matter with calmness and patience intact. For most of those families who come here, this may be the only courtroom that they enter, but they will remember their time here for the rest of their lives. The registrar who explained what was about to happen next, and the judge who listened to their facts. I also acknowledge there have been dark times in the history of our court. Justice David Opus was killed at his home in 1980. Justice Richard Gee and his children survived a bombing in 1984. And Mrs. Pearl Watson, the wife of Justice Ray Watson, was killed by a bomb at their home the very same year. That this court continues its work in the face of such evil is a testament to the resolve of those who serve on it. We must not allow them to be forgotten, even if they were not South Australian. They are the risks our court continues to face every day. South Australians have every reason to take pride in this court's capacity for family law renewal and continuous improvement. On the 7th of December 2020, Adelaide became the first registry in this country to screen for risk at the point of filing under the Lighthouse model. Brisbane and Parramatta registries followed a month later. The Lighthouse now operates in registries across Australia. The national reform was tested here first by South Australian practitioners, court staff, registrars and judges. Reform in Australian family law has more than once begun in South Australia, and continuous improvement in this court is continuous. This court today has not asked for the flattery of the profession. In the Adelaide registry, there is still delay, excessive cost of litigation, the resourcing of the court, and legal aid shortage that continues to be a real and pressing issue. The continuous improvement of the family law system is not just institutional housekeeping, it is essential to the public confidence in the rule of law itself. The family law section and the family South Australian law profession share in that responsibility willingly and participate actively with the court to promote access to justice in family law. We all have more to do. My point is, though, that the court is more than its building, its legislation and its procedures. It includes the hard-thinking judges who sit for long hours in difficult matters, the registrars offering pathways, interim protections and interim solutions. It includes the court child experts who work with parties in distress, the independent children's lawyers, the registry, the security staff, and the family law practitioners, both barristers and solicitors, who with their best help families find a way forward. No one does family law half-heartedly. Family law takes heart. And for 50 years, this court has served wholeheartedly. There are some who might consider that the work of this court is about endings, but those of us who practice here know otherwise. It is about beginnings, about protection where there may not have been any, fresh starts, and about hope for a better future for Australian families and children. On its 50th anniversary, this court is only 50 years young. We cannot know what changes lie ahead over the horizon, but what the past 50 years tells us is that this court's response will be marked by the same energy for self-improvement, continuous improvement, and the same respect for humanity that must underpin family law. On behalf of the Family Law section of the Law Council of Australia, and on behalf of all my South Australian family law colleagues, I congratulate the court on 50 years of service. I thank all who have served within it and wish the court well for the years ahead. May it please the court.
Thanks, Ms Jones. I thank each of the speakers for their generous remarks and the respect you've shown the court on this important occasion. For 50 years, this court has served families of South Australia with distinction, underpinned by innovation, resilience, dedication and enduring commitment to access to justice. Adelaide has been very much a part of that story from the very beginning. As one of the court's inaugural registries, it is especially fitting we mark this anniversary here. In a city and a state with a proud tradition of legal innovation, public service and social progress. Following much debate, as we've heard in 1974, and the near defeat of the Superior Court Act, not once but twice, which would have seen this court become a division of the Federal Court, this court was created as a standalone Superior Court of Record under the Family Law Act 1975. It brought together specialist judges and in-house counselling, services in a court designed to be less formal, more accessible, and encourage resolution rather than litigation. I'm not sure if those aims necessarily lasted for too long. This was not a new idea for the Adelaide legal profession. It was an idea that the federal government adopted from the South Australian model, where they already had court counsellors and social workers involved in children's matters. All states and territories other than Western Australia agreed to this new court, and WA was the subject of the court's appellant jurisdiction. Adelaide's place and significance at the very beginning of this court's history is prevalent. In the initial discussions of where the court was to sit, it was intended that a principal registry and registries should be established in Adelaide and in Canberra. However, in later discussions meant that the registries were set up in all capital cities except Perth. In fact, one of the founding members of the court, Austin Ash, told me before he passed a couple of years ago that when he was a silk in Melbourne as a family law silk, he was flown secretly in a Hercules aeroplane from Melbourne to Adelaide with other leaders of the profession to discuss the new proposed court. He was, in fact, the first judge sworn in Melbourne. On the 5th of January, as we've heard, 1976, the Honourable John Marshall was sworn in as an inaugural judge of this court in Adelaide. His appointment was affirmed Adelaide's place in the new National Court from its first day. The early work of the Adelaide Registry was shaped by the court's inaugural judges. John Marshall was quickly joined, as we've heard, by Kemery Murray and Tom McGovern in February 1976, with John Gunn joining the court in July 1976. Together they were entrusted with the formidable task of turning a bold legislative vision into a functioning institution for South Australian families. Kemery Murray's appointment forms an important part of South Australia's history of women leadership in the law. Before joining the family court, she'd been appointed as a district court judge in South Australia in 1973, becoming the second female judge appointed in Australia. In her 30 years of service to this court, she sustained concern for children and people affected by family violence, and deserved particular acknowledgement and mention today. The court's registries began in modest accommodation, as we heard, around the country, and Adelaide was no exception. The court's first home was in Grenville Street, before the court ultimately moved to this building in 2006. The opening of this court marked an important moment in the registry's history, as both a working court and a statement about what a modern court should be: enduring, accessible and connected to its community. The purpose is expressed most clearly in the dedicated First Nations courtroom, the Wadna Wadley, a place of decision-making developed with consultation with First Nations community leaders. It uses a circular seating, natural light, warm materials and local artwork to provide a more inclusive court environment. It is a powerful reminder that the administration of justice is shaped not by the law and procedure, but more by ensuring people feel heard, respected and able to participate with dignity. With the new court came a new jurisdiction and groundbreaking reform. The Family Law Act transformed the landscape of Australian family law, introducing no-fault divorce, as we've heard, and creating immediate demand of the court services. On the first day of its operation, queues formed outside the registries across the country as practitioners and parties sought to lodge applications for the new system. The response demonstrated the need for reform, the importance of specialised court capable of administrating that reform fairly, efficiently and with humanity. Within a decade, the court had processed more than 500,000 divorces. In the 5 decades since, the family law has evolved into a sophisticated area of law, requiring an understanding of commercial, corporate, trusts, bankruptcy, family violence laws, child protection and equity, and the intersection between state legislation and Commonwealth legislation. Throughout this time, the Adelaide Registry has been strengthened by appointment of leaders of the profession with distinguished advocates, solicitors and barristers who have brought their expertise to the bench and enriched the court. A significant milestone for family law practitioners and the Adelaide Registry occurred on the 4th of December 2009, with the appointment of the Honourable Steve Strickland to the appeal bench of the Family Court of Australia. It is an appointment of considerable significance as the first South Australian judge appointed to the Appeals Division, and was widely celebrated by the South Australian legal community and family law profession, following which Justice Strickland was administrative head of the Appeal Division nationally. It demonstrated that South Australian judicial officers continue to play an important part in shaping the national development of the court and the family law jurisdiction. I also have to mention Justice Berman, who is one of our finest and most productive trial judges, and who has been a great loss to the court, but a great benefit to the profession, or so he tells me. And across Australia, of course, Justice Mead, who has not only led the Federal Circuit Court with distinction, but also has made a major contribution to this court. This registry has also had the great fortune of having so many judges elevated from the Federal Circuit and Family Court of Australia Division 2, including the current Adelaide bench, with Justice Kari in 2021, and most recently Justice Parker and Justice Stewart in 2025, bringing with them considerable experience and deep understanding of the unique challenges presented by family law. As I've reflected in ceremonial sittings both here in Melbourne and also Sydney, the history of the court is also a story of courage and resilience through adversity. As has been mentioned, in the early 1980s, those times were some of the darkest in our court's history, in fact, in any court in Australia. It was marked by tragic murder of the Honourable David Opas and, as we've heard, Miss Pearl Watson, and the subsequent attacks upon members of the court. Of course, their families and the Parramatta Registry itself. It was a national disgrace that occurred. It was even greater disgrace that it occurred in such cowardly matters. And in fact, it was only a couple of years ago that coward was finally brought to justice. Today, we remember all those affected by those events and honour their service. In doing so, we recognise the remarkable strength of the court community, whose resolve ensured that the court continued its vital work in the service of Australian families at that time. Under those threats, they should be commended for their bravery, service and sacrifice. The work of judicial officers of this court can be challenging. It demands sound judgment, legal skills and a compassion in the face of some of the most complex and emotionally challenging disputes that come before any court. For 5 decades, judges and practitioners have responded to that challenge with distinction and brought exceptional skill and commitment to the jurisdiction. This court has benefited from the leadership of 4 outstanding Chief Justices: the Honourable Elizabeth Evatt AC, Alistair Nicholson AO RFD KC, Diana Bryant AOKC, and of course John Pascoe AC CVO. Each of these people have led the court through periods of significant change and they've made an enduring contribution. I again acknowledge and thank them for their service and of course the 2 Deputy Chief Justices before them. I also wish to extend my gratitude to judicial colleagues, past and present, and their families for their commitment to the institution that's so fundamental to society. The family law system is also operated within a spotlight of public scrutiny. Over the last 50 years, it has been subject to an amazing 75 reviews and public inquiries, more than any other area of the law. One can imagine that scrutiny has not always been easy. It's also demonstrated the value, resilience and willingness of this court to be introspective and adapt as necessary. As an aside, I can only imagine if that money, those funds, had actually gone to legal aid. If there was ever a time for the government to recognise, both state and federal, the need for more funding for legal aid, it is now. This court cannot administer justice properly and fairly without legal aid appropriately funded. The role that ICLs do in that case is quite extraordinary. They need to be funded too. It is a mockery. It's not done properly. I make no disrespect to the current federal government in relation to that, but for years they've been underfunded. One of the most significant reforms to this court came in 2021 with the passing of the Federal Circuit and Family Court of Australia Act 2021. The alignment of the two courts as the Federal Circuit and Family Court of Australia's Division 1 and 2 saw a more unified family law system, introducing common case management framework, rules, forms and procedures. These reforms have allowed the court to focus on the more complex of matters, seeing significant improvements in distribution times, reducing delays to trial, and almost halving appeal time. Yet while these structures and processes have changed, the court's core purposes have remained constant. Over the last 5 decades, the court has maintained its specialist skill set in ensuring safety of litigants and children in the most difficult of circumstances, and continue to dedicate itself to ensuring access to justice and being innovative in responding to the needs of Australian families. For example, the critical incident list, fast-tracking outcomes for families struck by tragedy, and of course the EVIT list, specialising in case management for matters involving family violence and heightened risk. The court has also continued to advance access to justice through the specialist Indigenous list and the work of Indigenous family liaison officers, who we're very proud of. Here in Adelaide, we've also seen the support and the benefits of the National Court Dog Program, with Court Dog Bonnie providing support for litigants and children during court proceedings and in court children's services. Often children have to come to this court facing arduous circumstances, whether it be a change of residence or indeed an appointment with a court child expert. Luckily now, they don't think of that harrowing time, they just remember that beautiful dog. I also have to tell you another story about the Court Dog program. Recently, we had a child who was involved in allegations that the child had been sexually molested by a family member. The child, when first interviewed, was unable to recite any of the details. The court child expert got the court dog in. The court dog came in, the child lifted up the court dog's ear and told the whole story. The court's work continues to be shaped by the realities facing Australian families today. Amongst the most significant challenges in family is family and domestic violence. Too many matters come before this court that continue to involve complex patterns of coercion, control and abuse. Over the last 50 years, the court's understanding of family violence has changed considerably, and the court is more alert than ever to ensuring that family violence is recognised and the outcomes of matters ensure that children and litigants are safe. The court is committed to supporting the government's 10-year national plan to end family violence against women and children. Whilst to date women have led the charge, it's time that male leaders step up and drive the conversations with young boys and other men as role models for positive behaviour, and help society understand this behaviour is simply not on. Let's hope that through the court's 50-year anniversary year, we can advance a nationally considered and coordinated response so that all Australian families can have a safer future. Finally, I wish to acknowledge the registrars, court child experts, Indigenous family liaison officers, associates, legal case management, administrators, corporate and registry staff of the Adelaide Registry. Your professionalism, skill and commitment continue the tradition established over 50 years ago. Your work, often behind the scenes, is essential to the administration of justice and the experience of families who come before this court. I want to also acknowledge the broader South Australian family law profession, whose skill and judgment and commitment have sustained this registry over 5 decades. The court can only serve the community well with the support of a strong and principled profession. Adelaide has been fortunate to have the support and that support from the beginning. In preparation for the court's 50th anniversary, interviews were conducted with former Chief Justices and judges. I now invite you to turn to the screen.
The Constitution of Australia has always given the Federal Parliament jurisdiction in, and I'll quote, marriage, and secondly, divorce and matrimonial causes, and in relation thereto, parental rights and the custody and guardianship of infants.
The family court opened in January 1976, and hundreds of people, if not thousands of people, came to the court.
I can remember the queue that went right downstairs, down the fire escape.
In the old days, to get divorce, you had to paint the other side black. Then you got a divorce on the ground of desertion or adultery or cruelty or drunkenness.
A lot of people had been waiting patiently for the Act to come into force so they could get their divorce.
Elizabeth Evatt started this court with very little in terms of resources.
They set to in those latter months of 1975 in trying to start a court from nothing.
We were a whole lot of like apprentice judges.
The Family Law Act over the last 50 years has swung like a pendulum one way or the other, depending upon the ascendancy of the interest groups that are vocal in the community.
There were certain elements in the community that were hostile to the family court.
There were a lot of protests, the black shirts, the men who were wearing black shirts and intimidating women.
And then David Opas was shot.
Leonard Warwick was ultimately convicted of 3 murders, blowing up the court building.
A family court is something more than a court. I think that on any view, it's the fact that this court has had a broader focus that stands out as one of its great successes.
The new court includes within its structure a counselling and welfare service.
It is, I think, in that respect, the envy of the world.
When I was Attorney General, there was little coordination and harmony between the courts, and the former government proposed effectively consolidating the courts administratively.
That represented really a significant, almost seismic change in the way the court had conducted itself. Things suddenly sped up, so it's been revolutionary.
I think it's absolutely vital that people have confidence in the court system. We have to make sure that we give fair and reasonable hearings, that we make sure that people actually are treated with respect. Risk identification has got so much better than it was. We now have to, as a matter of course, examine and have notices of risk in every case when it starts, not down the track. That makes a massive difference to their experience of the court, and we're able to diminish the possibility of them being further traumatised as a result of being in the court system. It's always been very controversial, these courts, because of the very nature of the work we do, the emotive nature of it. And I think the originators of this, I think they'd be really proud of the legacy they've created, but also each and every judge who's in the court at the moment and has been in the court should be really proud of what they've done. Over the last 50 years, this court has adapted to changing and challenging ways, changing laws and changing community expectations while being steadfast and committed to justice. Today we honour those who built that institution, we thank those who serve in it now, and we acknowledge the Adelaide Registry and its enduring contribution to the administration of family law across Australia. Thank you all very much for honouring us with your attendance today. Please join us for refreshments on level 10. Adjourn the court.
Silence. All standing, remain standing. The Federal Circuit and Family Court of Australia Division 1 is now adjourned.